In May of 2026, a residential street in Arroyo Grande, California, filled with equipment that does not usually appear in a suburban neighborhood. Ground-penetrating radar, soil probes, detectives sifting through papers and hard drives inside the house. 30 years, almost to the week, after a 19-year-old Cal Poly freshman walked away from an off-campus party and never arrived at her dorm room. By this point, the case had already been decided. A jury had convicted a man of her murder in 2022. A judge had sentenced him in 2023. An appellate court had affirmed the conviction in October 2025, and in January 2026, the California Supreme Court declined to review it, closing the last door on his direct appeals. And yet, in the spring of 2026, deputies were still turning over dirt. That's the tension worth sitting with for the next half hour, because it's the part of this story that almost never gets told properly. We tend to treat criminal cases as machines with a single output, guilty or not guilty. But a verdict answers a legal question. It does not necessarily answer a human one. Kristen Smart's family has a conviction. They still do not have their daughter. How does a case get solved and stay unfinished at the same time? The answer isn't a single villain or a single mistake. It's an accumulation of assumptions, of jurisdictional habits, of how institutions in 1996 were built to think about a missing college student over a holiday weekend. To understand why detectives were still digging in 2026, you have to go back to a stretch of time most coverage skips right over. Not the party. The 4 days after it. Kristen Smart attended an off-campus party on the night of May 24, 1996, and was last seen in the early hours of May 25th. Friends who saw her that night described her as heavily intoxicated. She was walked in the direction of the residence halls. She never got there. Her friends noticed quickly. They raised concerns quickly. The institutional response is where the story turns. It was Memorial Day weekend. According to the wrongful death and negligence lawsuit later filed by Kristen's family against Cal Poly, campus police did not pursue a missing person case promptly, operating instead on the assumption that a college freshman who couldn't be located had simply gone somewhere for the long weekend, camping, home, out of town, with friends. By the time a serious investigation was underway, roughly 4 days had passed. I want to be careful here, because it would be easy to turn this into a story about lazy officers. It isn't. It's a story about a heuristic, a mental shortcut that is correct the overwhelming majority of the time. Most missing college students are not missing. They are somewhere the people looking for them don't know about. Any campus police department in the country could tell you that in 1996, and mostly they'd be right. The shortcut works. The problem is that a shortcut that works 99 times out of 100 is still catastrophic the one time it doesn't, and it is precisely in the first hours that a case is most solvable. Scenes are still intact. Memories are unrehearsed. Nobody has had time to think. There's a second structural issue that receives almost no attention. Campus police departments in that era occupied an awkward dual role. They were law enforcement, but they were also part of a university, an institution with a powerful, largely unconscious interest in student incidents resolving quietly and internally. That's not a conspiracy theory. It's an organizational reality that higher education has spent the last 3 decades legislating around. Kristen Smart's own case is part of why. In 1998, California enacted the Kristin Smart Campus Security Act, requiring publicly funded institutions in the state to establish written agreements with local law enforcement for handling violent crimes involving students. In other words, the specific ambiguity that slowed her case became the thing the law targeted. Then, there is the detail that lands hardest. The family's lawsuit alleges that the dorm room of the primary suspect was not sealed as a crime scene and not searched until 16 days after Kristen disappeared, by which point students had moved out for the summer and rooms had been cleaned in the ordinary course of the academic calendar. Cal Poly declined to comment on pending litigation. But in May 2023, the university's president publicly apologized to the Smart family, acknowledging that things should have been handled differently. An unusual admission for a public institution, and the event the family cites as the moment they began to grasp the scope of what had gone wrong. 16 days. Think about what that number actually costs. Not just evidence that might have been recovered, but evidence that could never afterward be interpreted, because any trace found later could be explained away by everything that had happened in the room in between. Defense attorneys would make exactly that argument 26 years later, and they would not be being unreasonable. That's the first thing this case teaches, and it's genuinely counterintuitive. The most damaging investigative errors are rarely the ones that lose evidence. They're the ones that make evidence ambiguous. Here's a part of the story that gets flattened into a single sentence in most retellings, and it deserves much more. Before May 1996, Kristin Smart was not the only student at Cal Poly with a bad feeling about the young man who would become the suspect. At trial, prosecutors called witnesses who described a pattern. A student who turned up in a residence hall he didn't live in, who made women uncomfortable, who had a nickname among students, one I won't repeat here, that told you exactly how he was perceived. One student athlete testified that he knew of him specifically because women had told him they were uneasy. The family's civil complaint against the university goes further, alleging that reports had been made about threatening, stalking, and harassing behavior before Kristen disappeared, and that the university failed to investigate or discipline appropriately. The complaint also lays out 9 separate alleged incidents involving at least 12 women between 1996 and 2020. Those allegations have not all been adjudicated, and the university has not conceded them. But set the litigation aside and look at the human system underneath, because this is where the case has real educational weight. What existed on that campus was a whisper network, informal, decentralized, remarkably accurate, and completely invisible to the institution. Women warned each other. They adjusted their own behavior. What almost none of them did was file a report, and the reasons are the same reasons that show up in campus safety research to this day. The behavior felt too minor to formalize. The reporting process felt disproportionate or humiliating, and there was a widespread and often correct belief that nothing would come of it. The tragedy of a whisper network is that it protects individuals while leaving the pattern unrecorded. 10 women can each hold one piece of information, and none of them holds the picture. Institutions only see patterns when information is written down, and the informal system by design writes nothing down. That's not hindsight moralizing, that's a specific fixable failure mode, and it is arguably the single most transferable lesson in this entire case. By the time investigators did examine the dorm room, the physical scene was compromised. What they had instead was something stranger. In June 1996, trained human remains detection dogs, cadaver dogs, were brought to search the residence halls. Handler Adela Morris, later recognized by the trial court as an expert in the field, testified that the searches were conducted blind. She was not told which rooms were of interest. Her dog Chola ran the hallway, doubled back, showed interest in several doors, and alerted at room 128. That was the suspect's room. A second dog was then brought in as a comparison. Testimony at trial established that multiple dogs across the search reacted at the same location. Now, how much should that be worth? This is a real forensic controversy, and it deserves an honest treatment rather than a dramatic one. Human remains detection dogs are not instruments. They cannot be calibrated. Their error rates are difficult to establish in field conditions, and they are exquisitely sensitive to handler cueing, the well-documented phenomenon in which a dog reads its handler's expectations rather than an odor. Defense attorneys attacked the handler's credentials at trial, at one point characterizing them as volunteers rather than professionals. That critique is not frivolous. But notice what the blind search protocol does to it. If the handler doesn't know which room matters, she cannot cue the dog toward it. That single procedural choice Made in 1996 by investigators who could not have known it would matter in 2022, is the difference between evidence a jury can rely on and evidence a defense attorney can dismantle. One juror later told ABC News that the dog's alert at the bed was among the details she found convincing. There's a broader point here about how juries actually reason. We like to imagine deliberation as an evaluation of scientific reliability. In practice, jurors weight evidence heavily when it feels uncorrupted by human intention, when nobody could have arranged it. A dog that doesn't know what it's looking for, guided by a handler who doesn't either, has a kind of innocence that a confession or an eyewitness identification simply doesn't. For 25 years, the obstacle was always the same. Kristen Smart's remains were never found. Here's a misconception worth correcting, because it's one of the most persistent myths in true crime. The belief that you cannot convict someone of murder without a body. That has never been the law in California or anywhere else in the United States. What the law requires is proof of the corpus delicti, literally the body of the crime, meaning proof that a death occurred and that it resulted from a criminal act. A corpse is one way to prove that. It is not the only way. Kristen Smart was declared legally dead in 2002. Prosecutors would eventually argue the fact of her death through the totality of circumstances. A young woman with no history of disappearing, no financial activity, no contact with anyone who loved her across decades. The practical problem was never legal doctrine. It was that a no-body case leaves prosecutors nothing to anchor a jury to. So the case sat. There was surveillance, there were wiretaps, there was a grand jury. There was a civil deposition in 1997 in which the suspect invoked the Fifth Amendment repeatedly, legally unremarkable and constitutionally protected, but corrosive to public patience. What changed the trajectory was not, in the first instance, law enforcement. It was a musician from the Central Coast named Chris Lambert, who was a child when Kristen disappeared and who launched a podcast called Your Own Backyard in 2019. It has been downloaded millions of times. It brought forward witnesses. It reorganized a quarter century of scattered material into a narrative the public, and, critically, people with information, could follow. In March 2021, detectives served a search warrant at the Arroyo Grande home of the suspect's father, Ruben Flores. They used ground-penetrating radar and hand tools. Prosecutors would later allege that a disturbance in the soil beneath a deck was consistent with a burial site that had been emptied. Forensic testing of soil samples produced results the prosecution characterized as consistent with the presence of blood. In April 2021, almost exactly 25 years after Kristen vanished, Paul Flores was arrested and charged with her murder. Ruben Flores was arrested and charged as an accessory after the fact. Neither arrest included the recovery of Kristen Smart. The trial that followed is, structurally, one of the most instructive proceedings in recent California criminal practice, and almost nobody talks about the mechanics. The defense won a change of venue, arguing that decades of local publicity made a fair trial in San Luis Obispo County unlikely. The case moved to Monterey County, where jurors were drawn from a pool of more than 1,500 residents. Judge Jennifer O'Keefe presided. Proceedings were not televised. Then came the unusual part: dual juries. Father and son were tried together, but each defendant had his own panel of 12. They heard their own opening statements, their own closing arguments, and were excused from portions of testimony that applied only to the other man. It's a device courts use to preserve joint efficiency while protecting each defendant from evidence that would be unfairly prejudicial to him alone. The prosecution called more than 50 witnesses, the defense called 4, and then the two panels reached opposite conclusions. Paul Flores' jury deliberated roughly 4.5 days across, 2 weeks, and convicted him of first-degree murder, the theory being that Kristen died during an attempted in his dorm room. Ruben Flores' jury deliberated about 6 hours and acquitted him. 6 hours versus 4.5 days. That gap is the most misunderstood thing about the outcome, and it's worth being precise about what it means. An acquittal is not a finding of innocence. It is a finding that the prosecution did not prove its specific charge beyond a reasonable doubt. The charge against Ruben Flores required proof that he knowingly helped conceal a crime after it occurred, a narrower and harder thing to establish than most viewers assume. Soil evidence at a property can support an inference that something was buried there. Tying a specific person to specific knowing acts of concealment decades later without the remains themselves is a different evidentiary problem entirely. Two juries in one building, working from overlapping evidence, produced different verdicts because they were asked different questions. That is not a system malfunction. That is the burden of proof operating exactly as designed, applied defendant by defendant. And it's a distinction that public commentary about this case routinely collapses. Ruben Flores was acquitted. That is where the law leaves it. Paul Flores was sentenced in March 2023 to 25 years to life. Then came the appeal, and the appeal reveals something genuinely uncomfortable about how this case was won. His appellate attorney raised three principal arguments. First, that the trial court improperly admitted testimony from two women who described uncharged sexual assaults. Second, that the court should have removed a juror the defense believed had lost the ability to remain neutral. Third, that the jury instruction defining attempted rape was flawed. The requested remedy was reversal or reduction to second-degree murder. The first argument touches a deep principle in criminal law. Courts are ordinarily hostile to what's called propensity evidence, proof that a defendant did something bad before, offered to suggest he did the charged thing too. The concern is obvious. Juries may convict for who a person is rather than what the evidence shows. California, like many states, carves out a statutory exception for certain sexual offense cases on the reasoning that these crimes are committed in private, rarely witnessed, and chronically underreported. So pattern evidence carries unusual value. That exception is precisely what allowed prosecutors to argue intent in a case with no scene, no remains, and no confession. It is not an exaggeration to say the case may have turned on it. In October 2025, the Second District Court of Appeal affirmed the conviction. The court found the trial judge had not abused her discretion regarding the juror and, significantly, concluded the evidence was sufficient for a jury to reach its verdict even without the two women's testimony. It found no cumulative error requiring reversal. In January 2026, the California Supreme Court denied review, exhausting his direct appeals. There's a second irony worth naming. The podcast that resurrected public attention also became part of the legal terrain. Extensive publicity was central to the defense's successful venue change. Jurors later told the San Luis Obispo Tribune that they turned to the podcast and news coverage after the verdict. Some describing a sense of validation, one expressing anger at how long the system had taken. Independent journalism functioned here as a genuine investigative force multiplier, and simultaneously as a variable defense attorneys could work with. Both things are true. Any honest account of modern true crime has to hold them together rather than pick the flattering half. Which brings us back to the spring of 2026. On May 5th, deputies served a search warrant at a home on East Branch Street belonging to Susan Flores, Paul Flores's mother. Investigators used ground-penetrating radar and specialized soil testing designed to detect compounds associated with human decomposition. Sheriff Ian Parkinson told reporters the property had been searched back in 1996, but that the technology available now is not what was available then, and that authorities had received results described as consistent with the possible presence of human remains. He also said investigators were examining papers, writings, and electronic devices inside the home. The sheriff stated publicly that Susan Flores remains a person of interest and could face prosecution if evidence supports it. It's important to be exact about the status here. She has not been charged with any crime in connection with this case and has long denied involvement. A person of interest is not. A defendant and a sheriff's public statement is not evidence. The search concluded that Saturday, Kristen Smart was not recovered. The Smart family thanked detectives for staying with it. Their civil suit against Cal Poly, alleging negligence, negligent infliction of emotional distress, and wrongful death, has moved through the pretrial machinery of demurs and mediation, with the university contesting, among other things, the timeliness of claims arising from 1996 conduct. The family's position is that they could not have understood the scope of the failures until the president's 2023 apology. 30 years on, the legal questions are largely settled. The human one isn't. Most true crime treats a conviction as the end of a story. This case argues otherwise in 4 ways. It shows that the decisive moments in an investigation often occur before anyone believes there is an investigation, in triage decisions made by people applying reasonable assumptions to an unreasonable situation. It shows how a community can hold accurate knowledge in a form no institution can act on, and how the fix is unglamorous, making informal warnings easy, safe, and routine to formalize. It shows that convictions can be built out of absence, through blind protocol forensics, pattern evidence, and legal doctrines most people have never heard of and would find surprising, and it shows the gap between justice and resolution. The state got its answer in 2022 and defended it through 2026. A family still walks out to a dig site and hopes. Kristin Smart was 19. She was a first-year student who liked the ocean, who had a life that was barely underway. Everything you've just heard is a consequence of her absence, not a description of her. And it's worth saying plainly that no verdict, no appellate opinion, and no soil analysis restores what her family lost on a holiday weekend in 1996. The digging continues because someone decided that finding her still matters 3 decades later, after the legal outcome was already secure. That, in the end, may be the most humane thing in this entire case. If a case can be fully prosecuted and legally closed while a family still has no answer about where their loved one is, should we be measuring investigative success by convictions at all, or by something else? And what would that something else actually look like? Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.